I don't like sharing, when I'm in the spotlight, I don't like sharing the spotlight with PowerPoints. I'd rather that people focus on me and what I have to say. So even in my classes, I say that there's death by PowerPoints these days, so I'm not going to do that. But I wanted to have a conversation generally. And many of you would have already seen in terms of what has been published, the books that have been handled. That is a chapter that I've contributed, which is focusing on the paralysis of mining laws and implications on economic development. Now, I think it's about 54 pages. So what I'm going to do is that I'm not going to give you 54 pages of conversation today, but I've tried to synthesize that around what I call the paradoxes of law. So I'm going to give about 7 paradoxes, which I think are central to the piece that you're going to be reading. Now, the broader question that I am trying to answer in the report is that why does law produce, or why do we produce more law, but the law we produces less governance, right? So why does more law produce less governance? Is the question that I want us to kind of think through. And if you go through the report, I try to trace the historical and institutional evolution of our mining regime from the colonial ordinances that vested mineral ownership in the Crown, the British Crown, then the post-independence nationalizations under Nkrumah, then to the liberalization reforms in the 1980s under the structural adjustment programs, and then now till we have the Minerals and Mining Act of 2006, which in some regard consolidates all of them. Now, one of the things that runs through our legal framework is that we inherited what we call the regalian principle, which is this idea of vesting all the resources within the sovereign or the crown. But along with that also came a habit of centralization of power in the executive in terms of how the framework works. Now, I think that so far everybody will kind of agree that the conversation we're having over and over again is that we don't have an absence of law within the space, but perhaps we have an overproduction of law. Okay? And in every law then is also more institutional power, more mandates, more procedures that we keep repeating. But then none of these, both on the legal front but also in the institutional front, speak to each other. And when I say they do not speak to each other, I think that we have developed the habit as legislative drafters of saying that when we are saying that we want coordination, we say that the chief executive officer of the Forestry Commission would be on the board of the EPA. Then the CEO of EPA will be on the board of the Forestry Commission. So our sense of collaboration in terms of their work is reduced to board representation level. And that's kind of how we are trying to cure it legally. But when we need them to speak to each other, and at the core of the paralysis, is that you have bureaucratic presence but no systemic coherence. For instance, so when you take the Minerals Commission, the Forestry Commission, Water Resources Commission, the EPA, all of them operate their own information systems. All of them have their own permit databases, and all of them have their different reporting formats. None of them are interoperable. Okay? Then, so when a person applies for a license from the Minerals Commission, the environmental data which is attached to it is not shared or uploaded to the EPA's own environmental permitting database. There's no digital link that alerts the Forestry Commission that the area in which they are given the license affects a forest or a forest reserve. You don't know. In the same way, the Water Resources Commission doesn't even know in terms of the licenses that have been given, which water bodies are found within those spaces as well. There's also no integrated clearinghouse mechanism, which is that no single data platform where all applications, licenses, monitoring reports, field inspections can be viewed, verified, and even updated across the institutions. There's no central repository for storing or archiving baseline environmental data, reclamation plans, and even water quality readings across the various agencies that are doing this. So for instance, field inspectors from the EPA would collect data manually on paper, and those findings are not synchronized with the Minerals Commission's own monitoring unit and are not shared with the Water Resources Commission Basin Secretariats. So in essence, what you have is that every agency has compliance record which is incomplete. So a mine may have passed environmental audits but failed its reclamation obligations, yet these reports are not cross-referenced and the license continues to remain valid. Similarly, when the Forestry Commission grants consent for mining, under LI 2462, for instance, or any of the others, the data on approved coordinates are not automatically shared to the other places, the other agencies as well. So in an industry where everything is fast-moving, information itself is a form of paralysis in terms of how the agencies are supposed to operate across board. So what I'm going to do is that I'm going to try to illustrate the problem of law through what I identify as 7 paradoxes itself that are within the body of law itself. 1, the first paradox is that what law gives, law takes away. What law gives, law takes away. And what do I mean by that? So law gives the power to allocate, to regulate, to grant rights and privileges, but we rarely account for what it takes away in the process. So for instance, we have to begin to see law that is granting licenses and permits as some form of legal dispossession as well. And what do I mean by this? In all these areas, so many people are waking up to the loss of farms and also the cutting down of cocoa trees in many respects. So every time we give a mineral license, we are taking away from our own ability to ensure food security. But we are not accounting for that, and we are not being able to account for the depletion of farms that produce food for us across board. We don't have any data speaking to that. In the same way, you have the Cocoa Board, which has, for instance, committed syndicated loans that committed to sell or has already sold beans of a particular quantity, cocoa beans of a particular quantity. But in the same period, we have given licenses which are resulting in the cutting down of cocoa farms, which is mean that our projection as to what cocoa beans we can be able to provide to those we have sold is already gone. And we are not able to account for that as well in terms of how we operate the law. So what I'm saying that what law gives with one hand, it's taken with the other. So it gives us mines, large and small scale, but it's taking away our food security, it's taking away our identity as a country of cocoa and chocolate. Then the second is that law capacitates and also incapacitates. That's the second paradox. So what law is doing is, in fact, distributing capacity, but also incapacity. And what do I mean by this? So you have agencies that have overlapping mandates, which, produces paralysis, as we've been talking about. But then if you take the Minerals Commission, for instance, once the Minerals Commission grants a mining lease, the EPA feels obligated to grant an environmental permit. And when I say obligated, this is what I mean. That they have mechanisms for what you need to abide by in order for them to grant you the permit. So what they are doing essentially is that whether or not your environmental impact assessment has passed, but they are not assessing it against their own institutional capacity to be able to monitor and enforce compliance. So rather than it being an assessment of institutional capacity to be able to monitor and enforce compliance, it's a question of whether or not you have passed your EIA process. So you have EPA saying that there are fewer than 50 inspectors to monitor over 350 registered large-scale mines and over 2,000 small-scale operations nationwide. The Forestry Commission lacks the budget to conduct post-mining audits in most forests. And also so while each agency is acting lawfully, none of them can ensure continuing compliance or reclamation across board. So in effect, law has produced institutional incapacity by design, because every law empowers the agency to act in isolation but doesn't equip it to coordinate, share data, or jointly enforce compliance. So the result is a system where I say everybody has power, but no one has control. The third paradox is the fetish of legality. And we know that in our language, right? Like even when we say we are defining Galamsey, our first thought is to say illegal mining. Whereas we all agree that illegal or legality is not what we are looking for. It's about the responsibility of mining. It's about legitimacy of the operations that are going on across board. So the fetish of legality has become the instrument under which we debate each other and, in fact, defend and deflect. So anytime, for instance, where we are talking about gold board and where they are sourcing minerals, the question then becomes whether or not the persons are licensed mines, right? Like they are legal. But the question is not legal. The question is about whether or not they are compliant with environmental obligations, whether or not they can actually do this. So this veneer of legality has created a system where, when you go to the gold board, why by the time they sell and it goes through the formal chain, the gold then becomes some sort of gold laundering, in essence, because it becomes then authorized, the state sanctioned in the process. So the fetish of legality is also one. Then the institutional paradox, which is more law, less governance. Now, when you go through the report, you see that you have analyzed more than 30 separate acts and legislative instruments, including 6 major ones under Act 703, that we are continuing to see the production of more and more law, but that multiplication of law has not been matched by coordination, capacity, or accountability within the space. And anytime 2 or 3 agencies meet, or anytime there's a stakeholder meeting, we express reform through the language of more law. So we always have to continue to tinker the legal framework. It's like the law is never sufficient. And the problem is always expressed through inadequacy of the law itself. But we know that at the very heart of the unenforcement problem, one is the fact of unenforcement, but that there's a moral corruption of the enforcement regime of law itself. That because we are unable to address, we produce more law because we can't figure out how to deal with the one we are not able to already existing that we can't address. The third paradox is law as discretion. Law as discretion. So at the heart of our legal regime is an expanded regime of ministerial discretion. Any power that is given to any agency can be overridden by the minister. Everything that has to be done is not a technocrat decision, and the limits of their decision is always subject to the vetting of how power operates and the discretion that is given to the minister. So constantly, everything evolves within the minister's discretion, and by effect of it, that discretion, which is itself unguided, can easily be guided by other considerations, as we all know. The next one paradox is that the law is constantly also against itself. So law against itself, that we can agree that as far as this sector is concerned, that the state is not acting lawlessly, it is paralyzed by law itself. So too much fragmentation, too much centralization, too much disconnection from enforcement realities means that constantly there's a ritual of a legal order that is less about, that we must continue to envisage a legal system where it is less about the ritual of licensing, which is something which we have built expertise in terms of how we draft. Licensing, permitting, those procedural, these things is where we put a lot more emphasis on. But that the law does not necessarily enable legitimacy of the operations. Okay? So legitimacy thinking can be about, for instance, the conversation about FPIC, free, prior, informed consent, that a farmer does not wake up today and then they say that some people in Accra have issued a license for them to come and take over where you get your daily bread from. So that Accra then, through the instrument of law, is maintaining almost a colonial relationship with the rest of the country in terms of it comes in the forms of dispossession. When people come, they take away from you. And then the seventh paradox I want to highlight quickly is that, can we talk about law without enforcement? Is there law itself if law is not enforced? Now, for those people who go to law school, one of the things that they love to do is to always ask themselves the question whether international law is law. And one of the reasons why they keep asking themselves whether international law is law is that because international law has no policeman who is enforcing it, the question then is that domestic law has enforcement capability, and that's what makes it law. And for which reason, because international law lacks that, it is not law. But the same thing can be said then of domestic law. Our entire legal framework, it's haunted by lack of enforcement. So that the idea of enforceability exists on paper and in rhetoric, but then in practice, it is sporadic or even many times non-existent. So we are in a state of suspended legality, that law does exist in some regard, but enforcement is, inshallah. So then, on the final point, how do we then break the deadlock from moving law as command to law as governance? And this is perhaps a need which law must go through that process itself, because much of law is formalism rather than functionality. And even as data continues to show us where regulatory failure comes from, law is unable to provide how we deal with weak enforcement capacity. And every time we then come here and then we would be in a dialogue of the deaf, right? This person points the finger at the other one, the other person points the finger at the other one. And then we are stuck in a paralysis where because the instrument of law itself has not been able to decode or unravel how it can get itself enforced in many respects. So to break this gridlock, there are three things which I think the research is talking about, which is one, the coordination gap. So this is the persistent overlap and rivalry among regulatory bodies. The accountability gap, two, the absence of effective oversight over executive discretion, and also the limited capacity of Parliament, right, and any of the agencies to ensure transparency and compliance. And then the legitimacy gap, which is perhaps crucial, that the alienation of affected communities from legal processes that govern their lands and livelihoods, and which continues to shape their reality around law enforcement around the country. So in a nutshell, this is kind of what the research looks like if you're able to sit through the entire 54 pages. Thank you.